So today we are going to start the first our special contract act, quasi contracts we have discussed. So we are starting with the contracts of indemnity and guarantee. When we talk about contract of indemnity, it's sometimes L is silent. So it is first thing we have to remember, it is the special contract act. And when we talk about the Special Contract Act, so the subject matter about which this particular contract is to be entered into, this subject matter is defined in the contract. The rights and duties of the parties are given in the contract. Right? So basically the nature of contract is defined, that with which respect this particular contract will be entered into. So in this particular thing, when we talk about contract of indemnity and guarantee, so this is basically, we can say, the saving the other person or promise the other person to save or compensate in case of a loss. So when we talk about contract of indemnity, so contract of insurance is a wonderful example or very good example of contract of indemnity. So when we talk about contract of insurance, in this particular case, there is a person who is a policy holder who has taken a policy for a particular cause, that if some loss is being suffered due to some specific cause, then the insurance company is going to compensate that loss if that loss is suffered by the particular party. So here when we talk about contract of insurance, so there we are aware of that there is life assurance contracts, where we also talk about the contract of annuity, and there are journal insurance contracts. In journal insurance contract, if the particular contract is taken for the medical reasons or for the hospitalization, etc., so there is a medical claim facilities are there, that loss is to be there. If there is a motor car insurance, so which type of policy is there, accident or any other situation is there, who all are the parties which will be covered, or if there is any loss with respect to the natural calamities or any other thing. So all these things are going to be there. And if we talk about the concept, so it says that in return of a premium paid by the policyholder as per the terms of the contract, the insurance company is going to cover the loss suffered by the party due to the specific cause which has been entered into for the particular contract of insurance. So in this case, we can understand that when we talk about the contract of indemnity is a special contract act where one party is being promised to save from the loss which has been occurred due to a specific reason. So in this particular situation, when we talk about the definition of the contract of indemnity, so contract of indemnity says that where one person promises the other person from loss caused to him by the conduct of the promiser himself or conduct of any other person, or the reason which is defined in the contract when this promise is being made to save the other party from the loss, this is called as contract of indemnity. And in the contract of indemnity, we have two parties, indemnity holder and indemnified. So if we talk about the definition of contract of indemnity as per section 124, so it says, give me a second, yeah. It says that a contract by which one party promises to save the other from loss caused by the conduct of the promiser himself or by the conduct of any other person is called the indemnity contract. So here, if A has promised B that you enter into a business transaction, or we can say the some particular project, and in this situation whatever loss will be there, I am going to suffer the loss. So A is going to bear that loss. So in this particular situation, it is the contract of indemnity where A has promised B to save from a particular loss which will arise due to the conduct of the promiser himself or any other person or any other reason defined under the contract. So contract of indemnity talks about basically promise to save the loss, promise to save the other person from loss or compensate. Save the other person from loss or compensate the other person from that loss. Compensate the other person from loss. So in this particular situation, we need to understand that the subject matter in the contract of indemnity is, that is, saving the other person from a particular loss. So we can understand further that the contract of indemnity is a contract where one party promises to save other from loss caused to him by the conduct of promiser himself or by the conduct of any other person or any other reason which is mentioned in the particular contract, right? Then a person who promises to bear the loss, that is, who gives the indemnity, is known as indemnifier. So indemnifier is the person. In the last example, indemnifier is A, who promises, right? And the person whose loss is covered, that is the person who those protection the indemnity is given, is known as indemnified and indemnity holder. तो अगर हम इंश्योरेंस कॉन्ट्रैक्ट की बात करेंगे तो आपका जो पॉलिसी होल्डर है जिसने इंश्योरेंस पॉलिसी ली है, दैट पर्टिकुलर पर्सन will be known as indemnified, or also can be called as indemnity holder, right? And for example, A has filed a suit against B in the court of law, and C makes a promise to A that whatever losses A will suffer on that suit, he will compensate him for the same. So a contract between A and C is the contract of indemnity. तो कोई भी रीजन हो सकता है जिस रीजन की वजह से लॉस हो और जो दूसरी पार्टी है उस पर्टिकुलर पार्टी को उस लॉस से सेव करे. So that's it, that in the meaning of contract of indemnity. And if we talk about the essentials, so the essentials or basic requirement is that there are two parties, indemnifier who promises to save from the loss and indemnified whose loss is to be saved or who is going to be compensated. And if we talk about the subject matter, so subject matter in the particular contract would be saving the other person from the loss. So it means that promise to save the other person from loss would be considered as the subject matter of the contract. Then in continuation, if we talk about the reason of loss, so that reason must have been mentioned in the contract. So loss may be caused due to the conduct of the promiser himself or any other person. And when a person saves the other from the loss caused by the conduct of third party, it should not be at the request of the third party. So there is a condition कि जो प्रोमिसर है वो खुद ही आपको उस लॉस से सेव करने के लिए ऑफर कर रहा है, जो दूसरी पार्टी है उसकी रिक्वेस्ट पे ये कॉन्ट्रैक्ट नहीं हुआ, एंड द लॉस कैन बी due to non-human agency such as fire or sea perils, as we have discussed in the contract of insurance. So there the particular reason can be due to the nature, human nature, or can be non-human as well. And the very important thing is that all the essentials of a contract must be present. So all the essentials of the contract must be present. It means that all the requirements for the formation of valid contract are needed. For example, intention to create legal relationship, offer acceptance, lawful consideration, capacity of parties, free consent, legality of object, agreement expressly not declared void, possibility and certainty of performance, and legal formalities if required. All the essential needs to be present in the contract of indemnity, or whichever special contract we will talk about. The basic requirement is that when we use the word contract, the contract word itself means the valid contract, and when we say valid contract, then all the essentials of valid contract needs to be present in the particular contract. Then in continuation, as we have discussed, that when we talk about the special contract, then the rights and duties, we say that when we talk about the meaning of the contract, we say that it gives rise to corresponding rights and duties among the parties. So in that situation, the one party right becomes the duty of the other, and one party duty becomes the right of the other party. So if we take example of A and B, so if we take A is the indemnifier, and B is indemnity holder or indemnified. In this particular situation, there will be certain rights of the indemnity holder and certain duties of indemnifier. And similarly, a indemnity holder have certain duties, and this will become the rights of the indemnifier. So when we talk about the rights of indemnity holder कौन है? Whose loss is to be made good, whose loss is to be recovered, or who is supposed to be saved as per the contract or compensated as per the contract. तो उसके क्या राइट्स है एज पर द इंडियन कॉन्ट्रैक्ट एक्ट? इज टू रिकवर ऑल द डैमेजेस. तो जो भी उसको लॉस हुआ है, जिसके लिए उसको लॉस से प्रोटेक्ट करने के लिए प्रॉमिस किया गया है, उस लॉस को वो रिकवर कर सकता है. To recover the cost of suit. If he has suffered some loss and he has filed the suit for the same, then the cost of suit will be recovered from the indemnifier who has promised to save him from the particular loss, or to recover some paid on a compromise. So if there have been certain kind of adjustment, out of court settlement, or some compromise, or any payment has been made by him, so it will also be considered as the loss in the particular situation, and the indemnity holder has the right to recover any sum which has been paid by him on account of compromise. Now, when we talk about the rights of indemnity holder or indemnified, so in this particular situation, he has the right that he was indemnity holder was compelled to pay. जितनी भी उसके ऊपर liability आएगी damages pay करने की सारा claim और जो loss है वो indemnifier से claim कर सकता है. For example, that we say that जो भी उसके in case of any suit और otherwise जितना भी उसको claim करना damage हुआ है, loss हुआ है, उस particular amount को वो जो भी हमारे कॉन्ट्रैक्ट के हिसाब से रूल है उस हिसाब से क्लेम कर सकता है. Here I can discuss the example of insurance policy again, that for example A has taken a mediclaim policy for rupees 2 lakhs, right? And in case of there has been certain illness and there has been hospitalization, and the expenditure of the treatment was rupees 3 lakh. So the contract of indemnity is up to rupees 2 lakh. So the Mediclaim, the organization, the insurance company is going to either pay directly to the hospital or reimburse this 2 lakh rupees, and remaining 1 lakh rupees he is required to pay out of his pocket. So when we say that in respect of any matter to which the promise or to indemnity applies, it means कि उसी damage को, here we are using the word damage, but it is a kind of the loss or the promise to save from the loss. So we consider that thing as a loss only. So in this situation, जो भी उसको damage हुआ है, जो भी amount in suit और otherwise उसने pay किया है, तो जिस particular cause के कारण उस लॉस को कवर करने के लिए कॉन्ट्रैक्ट ऑफ आइडेमनिटी मिला है या आइडेमनिटी अप्लाई है, तो उस बेसिस पे उस आइडेमनी होल्डर हैज अ राइट to claim that particular amount. All costs paid by the indemnity holder in defending the suit. So if the other party has filed a suit and the indemnity holder has incurred certain amount of expenditure to defend that suit, so all that cost incurred to him for defending any suit can be claimed from the indemnifier if it is as per the rules or the it is related cause for which indemnity has been given. एनी सम पेड इन कॉम्प्रोमाइज, तो जो भी कॉम्प्रोमाइज के लिए आपने पेमेंट की है, सो ही इज द ओनली क्वेश्चन इज कि आइडेंटिफाइड को एक बार प्रॉमिस कर दिया टू सेव फ्रॉम द लॉस, तो उसको किसी भी फॉर्म में लॉस अपने पॉकेट से पे नहीं करना है. फॉर एग्जाम्पल आई हैड गिवन एन एग्जाम्पल ऑफ that A has promised B to take a business project and whatever loss will be incurred by him, A is going to bear that loss. तो वो लॉस चाहे डैमेज के फॉर्म में हो, सूट के फॉर्म में हो, डिफेंडिंग ऑफ सूट के फॉर्म में हो, कॉम्प्रोमाइज के फॉर्म में हो, किसी भी फॉर्म में हो, A is bound to compensate that loss or to save B from that particular loss suffered due to the particular reason and therefore which the contract of indemnity has been entered into. Then there comes the liability of indemnifier. So because indemnifier has promised to save the other person to save from a loss, so in that case, what is the liability? So in this particular situation, the question arises that when he will be responsible, he will be liable to compensate. So there are two thought process are there or two rules are there. Rule number 1 says that because we are saying to save from loss, so the other party should not have suffered the loss at all. So in that particular situation, the moment the loss arises, the liability of indemnifier comes. So that moment, this is to be paid directly and the person should not be paid and there should not be any reimbursement. But in certain situation where loss can't be determined or it is yet to be determined, for example, a suit is being filed and court is yet to, the decision of the court is awaited. So in that particular situation, the moment the particular liability is finalized, is determined, the liability of indemnity holder arises. So it says the liability of indemnifier arises only on the occurrence of any loss to the indemnity holder, and the indemnity holder can be compelled to pay to make the loss good even before he suffered actual loss by paying off the claim. तो indemnified ने वो loss pay नहीं किया, but he is being promised to save from the loss. So the liability of the indemnifier will arise the moment the particular loss is suffered by the other party, even though he has not actually made the payment for that particular loss. Then there are, if we talk about the rights of the indemnifier, so in this regard, Indian Contract Act is silent on the rights of the indemnifier. So it is just based on the natural equity that the other person should not enrich himself at the expense of the other. So in that situation, the other person must have, as per the contract of insurance, must have put best of his efforts to mitigate the loss and all the other things are there. So on the basis of natural equity, indemnifier rights will be determined and would differ from case to case and would be decided by the court of law itself. So here we can, if we talk about when you'll study the contract of insurance separately, so there comes the right of subrogation, right of mitigating the loss, and right of equity. So all these things are going to be there. So that's it in the contract of indemnity. And generally in this particular chapter, because next in line is contract of guarantee. So generally a question comes as a difference between contract of indemnity and contract of guarantee. So I can take a pause here to ask you if any question is here. Yes. Any question with respect to contract of indemnity? Okay, can we move further?
Yes, ma'am.
Yes,
Okay, then let's continue with the contract of guarantee. Now, when we talk about contract of guarantee, so contract of guarantee requires basically concurrence of three contracts. तो contract of guarantee क्या होती है? That when one person is paying loan to the other person or entering into certain activity, one person is say giving loan to other person with a condition to have guarantor for that loan. So in this case, the guarantor will join on the request of the debtor. पर अगर गारंटर ज्वाइन नहीं करता है तो ये कॉन्ट्रैक्ट ऑफ गारंटी एंटर नहीं होगा. तो द पर्सन हु इज गिविंग द लोन is known as a creditor. The person to whom the loan is being provided is known as principal debtor, and the person who joins as a guarantor is known as a surety. So basically there is a contract between creditor and principal debtor, and this particular contract has arisen on the condition that a surety joins. और surety कब join करेगा? जब principal debtor उसको request करेगा to give make or to give the guarantee. So actually there exist three types of contracts. One contract is between the contract creditor and principal debtor. Then the second contract is between the principal debtor and surety. Sorry, second is between the creditor and surety. And the third one is between principal debtor and surety. So there are three separate contracts, and we have to understand that these contracts are in concurrence with each other. So when we talk about the meaning of contract of guarantee, so meaning of contract of guarantee says that when one person promises the other to pay in case of default by one person. So in this case, if we talk about the contract of guarantee, so section 126 says that a promise to pay the liability by surety in case of default of principal debtor. So we can say that in the contract of guarantee, there is a promise to pay the liability by surety in case of default by principal debtor. तो कॉन्ट्रैक्ट ऑफ गारंटी कब हो रही है? जब श्योरिटी उस कॉन्ट्रैक्ट को ज्वाइन कर रहा है. अदरवाइज द ए we can say creditor would have not given the loan to the principal debtor. So we say that A has given a loan of rupees 2 lakh to B, which is guaranteed by C. So in this case, C is promising to A that in case B will not return the amount, then it will be returned by C. So here the liability of B is the primary liability, and the liability of C or the guarantor is the secondary liability. So we will discuss about the rights and duties of the parties and how this particular, we can say, this particular contract can be entered into and will be performed as well. So we say contract of guarantee is the contract where there is a promise to discharge the liability of a third person in case of his default. So a contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. So it means that A has promised, A has given a loan to B, and C has promised to pay that loan to A in case there is a default by B. Right? So this is generally, we can talk about the security of payment in case of the, we can say the loan and the transaction. So we say a contract of guarantee is a contract to perform the promise or discharge a liability of a third person in case of his default. The person who gives guarantee is known as a surety or guarantor. The person in respect of whose default the guarantee is given is called principal debtor, and the person to whom the guarantee is given is known as a creditor. So there exist three parties. One is known as creditor, second one is known as principal debtor, and third is known as the surety. So there exist three parties known as creditor, principal debtor, and surety. Creditor is person to whom the guarantee is being given. Principal debtor is a person with respect to whose default the guarantee is being given, and surety is a person who has promised to make the compensation or promise to pay in case of default committed by principal debtor. So here we cannot use the word that creditor is a person who has given the loan and principal debtor is a person who has got the loan and surety is a person who is going to give the loan in case of his default. We have to talk in respect of the meaning of contract of guarantee, wherein we say that the guarantor is a person who is going to perform the promise in case of default of principal debtor, and the contract of guarantee principal debtor is a person who in whose default or whose non-performance the surety is going to make the payment, and creditor is a person to whom the payment will be made in case of contract of guarantee. Then in continuation, we need to understand the essentials of contract of guarantee, because we say the subject matter, how it will be performed, what will be the prerequisites, it is decided by it is given in the contract act itself, and the amount and the other things will be, terms and conditions will be decided by the parties. So in this particular case requirement, first thing is that there should be a principal debtor, and principal debtor is having the primary liability. And there are three parties: debtor, principal debtor, creditor, and surety. There are three contracts: debtor and surety, creditor and surety. Debtors and creditor and concurrence must exist, means that all three contracts should exist. So if there is a setting between the debtor and the surety that neither he is going to pay and nor the other person is going to pay, the valid contract will not exist. Or if there is an adjustment between the creditor and debtor, that let us join the third person as a surety, and you will commit the default and I will recover the payment from the surety. It cannot happen. All the three contracts between the respective parties must exist in case of contract of guarantee, and if there is any kind of discrepancies, then it will not give rise to the valid contract of guarantee, and hence the particular contract cannot be performed, and the surety will be discharged from his liability. So we'll also discuss about the discharge of liability of surety at later stage. Then primary liability is of someone other than the surety. अगर श्योरिटी की प्राइमरी लाइबिलिटी हो जाएगी तो वो कॉन्ट्रैक्ट ऑफ गारंटी नहीं कहलाएगा. बट इन केस ऑफ माइनर्स we have discussed that if there is a surety for a minor, then in that case surety will have the primary liability. If you remember this particular point, we have discussed at 2-3 places that when we talk about guarantor for the minor, because an agreement with the minor is void ab initio. So if someone is giving a surety for the loan given to the minor, in that case minor cannot be held liable, his property can be there, but when the guarantor is giving the guarantee, so in that particular situation surety will have the primary liability. So at this particular point, this sureties surety for minors loan will be an exception to the rule. Otherwise, there should be for a valid contract of guarantee, there should be a primary liability with someone else other than the surety. Then there must be consideration. So consideration is there, but surety is not getting anything in return. But the loan received by the principal debtor is the sufficient consideration for the surety to join the contract. So in this case, even if there is no consideration, still the contract between the principal debtor and surety and creditor and surety will remain valid. Creditor और principal debtor के अंदर तो आपका लोन मिल रहा है. Creditor is giving the loan to principal debtor, and principal debtor is might be giving the interest or whatever terms and conditions are there. But in case of creditor and surety के अंदर surety को कोई consideration नहीं मिल रही, and in case of principal debtor का लोन गारंटी करने में श्योरिटी को कोई कंसिडरेशन नहीं मिल रही, still these are going to be the valid contracts as per law, because the consideration received by the principal debtor is sufficient consideration for the surety to enter into the contract. Guarantee for past debts is not valid, because there will not be any consideration for any past debt. If the guarantee is being given, this will not be considered as a valid contract of guarantee as per law. Then no misrepresentation or concealment of material fact. तो अगर कोई material alteration होती है, कंपाउंडिंग होती है, कॉन्फ्रेंस नहीं होता, कुछ मिसरिप्रेजेंटेशन होता है, हाइडिंग ऑफ इंपॉर्टेंट फैक्ट्स होता है, तो उस केस में it will not give rise to the valid contract of guarantee. Hence surety cannot be held liable, because basically we say that it is a contract of guarantee is the promise to pay the money on behalf of someone else in case of his default. तो प्रिंसिपल डेटर अगर डिफॉल्ट करता है तो उस डिफॉल्ट के केस में आपका गारंटर जो है पेमेंट करेगा, बट वो तभी करेगा जब वहां पर वैलिड कॉन्ट्रैक्ट ऑफ गारंटी होगा. अगर वैलिड कॉन्ट्रैक्ट ऑफ गारंटी नहीं है तो आपकी जो लाइबिलिटी है आपकी श्योरिटी की, वो लाइबिलिटी भी अराइज नहीं करेगी. गिव मी अ सेकंड. ओके, right? So in continuation, we say all the parties must give their consent. So all the three parties must have the details of the contract about which the surety is going to give the guarantee, etc. And the consent of all the parties must be there for to make the particular contract of guarantee as a valid contract. Writing is not necessary. So as discussed number of time, that whether we talk about the verbal contract or we talk about the written contract or we talk about the implied contract. So in this case, implied contract will not be valid. But if we talk about the verbal or written contract, so these are valid. So even if the guarantee is not in writing, it is a verbal guarantee, then also it is going to be a valid contract, and essentials of a valid contract must exist. So it is the prerequisite that the particular contract, valid contract requirements must exist in the contract of guarantee. So I repeat again that there needs to be an intention to have legal obligation. As per section 10, for the formation of a contract, for the formation of a valid contract to be enforceable by law, there needs to be intention to have legal obligation. If there is no intention to have legal obligation, then the particular contract cannot be enforced by law. There needs to be offer and acceptance. There needs to be consideration, but for surety, we have discussed the exception. Then we have discussed that the parties must be capable of entering into the contract. We have discussed one exception where we say that if there is a guarantee for minors agreement, then in that case, the surety's liability will be of primary liability. Then we have also discussed that there needs to be free consent. The consent should be there of all the parties. Then, of course, there should be the object, which should be legal. If you are giving guarantee for any illegal transaction as such, the particular contract will not be valid. The guarantor will not be responsible to make payment or to compensate or to perform his part of promise. Then we also say that agreement not declared void, अगर वो void declared होगा और already declare होगा कि it is not enforceable by law, तो आप guarantor को you cannot catch hold of making the payment. Then we say possibility of performance, so it should carry the object which is possible to perform. So guarantee should not be anything which is the activity which is not possible to perform. And if any legal formalities etc are required for the performance of the contract in the court of law, then such legal formalities must be there. So for example, if any particular for the along with the guarantor, some security or some particular property papers are being mortgaged, or some fixed deposits or some other item has been given as security. So if legal formality are there, so for mortgage detail, these must be mentioned in the contract. So if any legal formalities are needed, required, these must be fulfilled. So all the essentials of a valid contract must exist. जब वो contract एक valid contract के form में exist करेगा, प्लस वो सारी की सारी जो essentials हैं of contract of guarantee fulfill करेगा, then only the surety can be held liable to perform under the contract. And in case of non-performance by principal debtor and surety as well, the other person can go to court of law and file suit for performance or compensate for non-performance as the situation arises. So this is the cycle which we have earlier discussed, that why the formation of contract is there and how it is to be performed. All these things have to be there. Then we talk about the types of guarantee. So types of guarantee can be specific guarantee or simple guarantee. So if there is any specific purpose of transaction or any one specific contract, and for that specific transaction or that specific contract, the guarantee is being given, will be known as the specific guarantee. And if it is for the series of transactions, then it will be known as the continuing guarantee. So how the guarantor is responsible in both the situation, we will be discussing in the next class only. And when we talk about the guarantee which continues even after a particular purpose or transaction comes to an end, is known as continuing guarantee. So there we, in the meaning of continuing guarantee, we can say that for example, that A has given a loan to B of rupees 10,000 and it is to be guaranteed. So if the C joins as a surety or guarantor for this transaction, this will be known as the specific guarantee or simple guarantee. And if A says that you hire B as your employee and I will be responsible for his conduct in business, and if there will be any loss or any misappropriation done by B, I will be responsible. So it means that till the time B is working or continuing, so if you are not limited the guarantee by time or by amount, then it is a continuing guarantee. So till the time B is working, until the time he has not committed any misconduct or misappropriation or loss, so the guarantor C will be held liable in that particular situation, or whosoever is the guarantor in that particular transaction. So it will be known as the continuing guarantee. And then nature and extents and the liability of the parties, etc., we will be discussing in the next class only. We can take up the difference between the two contracts right away, that I would like to discuss because we still have some time. So we'll take only 5 minutes to discuss the difference. And my dear friends, whenever we talk about the difference questions and all, so I have already told you कि एक statement वाले questions और एक difference वाले question अगर आप कर लेते हैं तो उसमें से majorly जितने आप questions prepare करोगे, so most of the questions would be there in your exam. So if we talk about the contract of indemnity and remaining about the liabilities and all, which we'll discuss later, so we can add up those differences at later stage. Till now, whatever we have covered with respect to the meaning and nature of contract or other things, we can discuss it right now. So the first difference would be with respect to the meaning. So this is given in section 124, when one person promises to save the other person from loss arising due to conduct of that person, promiser himself or any other person, is known as contract of indemnity. And section 126 talks about the contract of guarantee, where one person promises to save, promises to pay or meet out the liability in case of default by another person, is known as contract of guarantee. And if we talk about the parties, so here we talk about the two parties are involved, that is known as indemnifier and indemnity holder. And in case of contract of guarantee, there are three parties are involved. Then you can name all the two parties and three parties respectively. Then we talk about the number of contracts. So when we talk about the number of contract, so there here it is only one contract, and here there are three contracts. Then we talk about the subject matter. In the subject matter, here we talk about the saving from the loss, and here we talk about the payment in case of default committed by the principal debtor. And if we talk about the types of the contract of indemnity, so here it can be, the reason can be the person or non-person, human nature or non-person. And here we talk about the types in terms of, we can say that the generally the payment of loan or that thing is there, or also we can, even if we want to take that, there can be only one type of contract of indemnity, and here can be the specific guarantee or continuing guarantee as well, right? And we can say again types में इसको consider कर सकते हैं. And what else difference we can take, we can say the difference in terms of what else point we have discussed till now about the nature of liability we have covered, and number of contracts we have covered. Yeah, occurrence of liability. When we talk about occurrence of liability, so here we talk about the two stages, but आपने वो stages mention करनी है, मैं सिर्फ आपको बता रही हूँ कि किस चीज के बारे में लिखना है. So here you have to write that there is the liability of the indemnifier arises as soon as the loss is occurred, even though it is not suffered, and in certain situation where loss is to be determined or liability is yet to be identified, the indemnifier can be called upon the pay the moment the loss occurs. And here when we talk about the rules, so occurrence of liability will come subject to certain rules which we will discuss in the next class. So these rules कि पहले फर्स्ट स्टेप क्या है, राइट्स ऑफ क्रेडिटर क्या है. So all these process we have to follow. And if we talk about the consideration, so in this case consideration is there, that the person himself is offering the other person to save from the particular loss. And here the consideration is about the loan given by the creditor to principal debtor, and with respect to the surety, the consideration received by the principal debtor is the sufficient consideration in the contract. So only we are left with the liabilities of the party and the rights of the parties. That difference is left, that we will once will be through with the other the continuation of contract of guarantee, rights of surety, liability, and the other situations, then we will be able to discuss this difference as well. So I hope till now, whatever we have discussed, the concept is clear to all of you. And if you have doubts, so we can take up the doubts now.